Good evening and welcome to Law of Evidence, Historical Facts, and Geography from American Jurisprudence. Once again, we're going to continue on our exploration of the judicial notice portion of Law of Evidence, which has been quite extensive, but for good purpose. So let's get right down to it. So we're on to Chapter 4, Historical Facts, starting with Section 71, generally. Courts regularly take cognizance of matters, so we're talking about judicial knowledge here. Before we get started, just to remind everyone, this is strictly for the entertainment and educational purposes of the YouTube broadcast only, not to be used, misconstrued, mispurposed, or otherwise for anything personal, professional, legal, lawful, financial, tax, or otherwise. So please don't do this at home. That being said, let's get started. Courts regularly take cognizance of matters of general history and historical events. An adjudicative fact does not qualify for judicial notice, however, merely because it is of ancient vintage. Oh, wow. As with any adjudicative fact, it must be common knowledge or capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. So, common themes we see recurring here. So the courts regularly could take cognizance of matters of general history and historical events. But an adjudicative fact, meaning one that's going to apply directly to this case, not in general, does not qualify for judicial notice merely because it is of ancient vintage. So just because the matter of general history is old, it seems here, it must be common knowledge. It can't be some ancient book you pull out and say, look what I found. This is general history and historical event. Unless it is common knowledge or capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. Interesting there. That goes both ways. So, let's see, that came from footnote 89 for the ancient vintage as Oneida Indian Nation versus New York. The trial judge interpreting treaties and the Articles of Confederation. Wow, erred in judicially noticing records, notes, correspondence, histories, articles, and other data without at least giving both sides the opportunity to contest the propriety of noticing such materials. This one here is the admission of hearsay evidence was improper to prove that the historic use of a private road was a matter of common knowledge. As regarding hearsay generally, see sections 658 and the rest of that sequence. We're on to section 72. Before that, let's jump over here to the chat. Glad you get the satisfying vibra slap at the end there. And let me make sure the chat's refreshed here. Indeed, let's proceed. So, judicial notice has been taken. This is of facts of national or international concern. Judicial notice has been taken of the international situation which existed prior to entry of the United States into the First World War and the consequent development of our national resources. Judicial notice also has been taken of the Civil War, of the acts which led to it, and of the general social, economic, and financial results which followed it. In addition, judicial notice has been taken of the historical facts and events leading up to the adoption of a particular amendment to the Constitution of the United States, 93, huh? See what that could be. Burnett versus Niagara Falls Brewing Company. Interesting there. And the cooperation of federal and state authorities in a matter of joint concern. Dates of historical events have also been judicially noticed by courts where they are a matter of general or readily verifiable knowledge. So, readily verifiable historical events. general or readily verifiable. Matters, I guess, general knowledge or readily verifiable knowledge. So the dates of those historical events can be judicially noticed. So this is an important factor here if you're building a case, to be able to have dates that are relevant to historical events that might have further application down in the strategy. That would be a good idea to have them judicially noticed by the courts, where they are, of course, a matter of general knowledge or reliably verifiable knowledge. All right. Appeal after remand here. All right, we're on to section 73. State and local facts. State courts in particular take notice of historic facts peculiarly connected with or affecting the state, including the historical facts and conditions which precede and lead to the enactment of legislation on a given subject, and even salient facts of local history which are known generally in a particular community in the state. I wonder what the salient facts were. 98. See, United States versus Griffith. All right, nothing special here. Greyhound Lines versus Railroad Commission of Texas. Whew. Sounds like a dangerous case there. All right, section 74. Other particular matters. Notice may be taken of historic facts relating to religious history and practice. Interesting. Footnote 99, United States versus Dykema. Criticized on other grounds by United States versus Church of World Peace. That's an interesting one right here for footnote 99. So notice may be taken of historic facts relating to religious history and practice, politics, international and foreign history, and a variety of other subjects. Footnote 3. Brown versus Board of Education. Interesting. So there is judicial notice taken in that case, that's noted here. History of development of segregated schools in the South. All right. So we've completed the section on historical facts. Not very extensive, but I think the biggest takeaway from this is the fact that we got to right at the beginning, and we saw how this is over and over substantiated here with these cases. But the fact that they'll take matters of general history as long as it's not just ancient vintage, but because it's capable of accurate and ready determination, resorting to sources whose accuracy cannot be reasonably questioned, or must be general or common knowledge. Otherwise, it won't be qualified for judicial notice. All right, so we're on to section 75 in chapter 5 here of geography, political subdivisions. So, section 75, generally. Before we do this, let's jump over here to the chat and make sure this is refreshed. I wonder if a court has taken judicial notice of a common historic misconception, Bill Thomas says. You know, if the other side doesn't oppose and the judge doesn't contest it, it could happen, which brings forth some interesting results there if both sides believe in misconceptions, especially if the judge does as well. And considering religious dates and practices and customs can be judicially noticed in some situations and instances, that brings forth further questions about misconceptions. All right, good question there, and let's proceed. There's also silent notice. I wish you could give a little bit more elaboration on that, but we might be getting into that later, so let's just continue. So we're on to geography, political subdivisions generally. The courts take judicial notice of the prominent geographical and natural features of the country. So especially when we're talking in the terminology of geography, Prominent literally means to be jutting out like a mountain or anything that's a protrusion. And natural features of the country, such as the large lakes and rivers, the division of the country into states, the existence, location, and population of political subdivisions, and distances between well-known points. Courts also judicially notice the territorial limits of the United States. Footnote 9. Carroll versus United States. We saw this somewhere else. Criticized on other grounds by Terry versus Ohio. Now this is interesting here how this applies, because that's a major case here. Have to look into this one too. American Law Review 790. Okay. So this is an interesting fact here. Courts also judicially notice the territorial limits of the United States. Question whether a specific geographical fact is entitled to judicial notice is considerably simplified if the fact is the creature of statute. For, in such cases, the court will take notice of the statute and, incidentally, the geographical fact, regardless of the notoriety of the latter. So, however well it's known of a geographical fact, if it's noted in a statute, it's literally a creature of a statute, especially when you're regarding political subdivisions. If it's noted in a statute, then it's entitled to judicial notice, or it's considerably simplified, the choice, it seems, because it would be, regardless of the notoriety of the geographical fact that's being stated. So what's listed in the statute trumps what's stated as a geographical fact for purposes of judicial notice. The interesting one here is the territorial limits of the United States. I'd like to see what this judicial notice was in that case. I'm going to have to find that out and report back. All right, we're on to section 76, states and local subdivisions. Lots and blocks. We'll get to the lots and blocks. Let's check over here. Bill Thomas's audit them could be an expert witness in prominently displayed. Actually, the prominently displayed is a terminology, and the terminology used in geography is different than it is used in the FOIA statute, or the FOIA Act. So, but it still has the same etymology and the same general root meaning: to jut out, to stick out, be prominent. Prominent mountain features. I forget the exact terms that are used, but it is a geographical term, and therefore, when used in judicial notice, you make use of that terminology for this geographical fact. All right, let's proceed. Both federal and state courts take judicial notice of the location and boundaries of states, the division of states into counties, cities, towns, and villages, and the locations of these subdivisions within various counties, judicial districts, and other political subdivisions. A court may take judicial notice of the location of cities, counties, boundaries, dimensions, and distances, because geographic facts such as these are easily ascertainable and capable of verifiable certainty. Here's a comment. In determining the sufficiency of the evidence of venue, this is whether you're in the right court or not, appellate courts may take judicial notice of the official highway map of their state. Official highway map. Courts regularly take judicial notice of geographical features of the country, generally, and of the locality in which they sit. The geographical features. Judicial notice will also be taken of the fact that a particular industry is not in the state. Like it would have to be. The courts of the state take judicial notice of the political and territorial separation of the state into counties and the population of a county, the number of counties in the state having a population over a certain number, the area of a county, and the county seat. So these can all be noticed like you'd have to notice the county seat. In addition, a court may take judicial notice that a city is centrally located in a certain county, and that a location that is just outside the city's limits is therefore located in the same county. The courts take judicial notice of the charters of municipalities or of acts incorporating them. Charters of municipalities. Now, this is an interesting one here because courts will take judicial notice. So, if you were to FOIA certified copies of a charter of municipality or acts of incorporating them, that could be used for noticing the court with judicial notice, it seems. The court will take judicial notice of the location of cities, towns, and villages within the limits of their jurisdiction, at least where they are of significant size or importance. 24. Significant size or importance. Payroll versus Howard. Nope, nothing there. Okay. Looks like verifiable certainty. We went through that already. Okay, looks like there's nothing really special in the footnotes anyway, so that was worth jumping over there. For example, the courts of a state will take judicial notice of the county in which a municipality is located. Courts will take judicial notice of the population of municipalities within their jurisdiction. The courts will judicially notice that municipalities are divided into lots and blocks. 27. And that's just this case here in Oklahoma. All right, we're on to section 77. Particular location within a subdivision. All right. Let's check over here the chat real quick. And refresh so we get this up and current. And welcome to Audit Them. Yes, indeed. Our prominent auditor here in the house. So section 77, particular location within political subdivision. Most courts have considered the question most courts that have considered the question have concluded that the location of a street address as within a particular political subdivision is judicially noticeable. The same is true as to a particular intersection. Judicial notice may be justified because the location of a particular street address is likely to be capable of accurate and readily determination by resort to sources whose accuracy cannot reasonably be questioned. So you get this quote here. This is right out of the Rules of Federal Procedure or Rules of Evidence, I believe. Capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. Some courts, however, refuse to take judicial notice because the location of a street address within a particular political subdivision is not common knowledge. In addition, a court may take judicial notice that a recognizable location is within a particular parish, even though the parish is never specifically mentioned by name. Furthermore, that two particular cities are situated in a particular county is a proper subject for judicial notice, and whether a highway links two cities is a fact of such notoriety that there is no necessity of accompanying a request for judicial notice with additional background information in order for the facts to be mandatorily judicially noticed. A court will not, however, take judicial notice that the building in question, in a case in which a defendant is charged with violating municipal ordinances in connection with the maintenance of the building, is within city limits. See this again here. So we had two cases here at the end here which are interesting here. This one here has two highways linked two cities, fact of such notoriety there's no necessity of accompanying a request with additional background in order for the facts to be mandatorily judicially noticed. So there's a new term there, mandatorily judicially noticed. Court will not, however, take judicial notice that this building in question, which a defendant is charged with violating municipal ordinances in connection with the maintenance of the building, is within city limits. So they wouldn't take notice. That has to be adjudicated within the trial setting, it seems. See, that's footnote 34. Let's look at that real quick and come back to the annotation. Section 106. Okay. Well, we'll eventually get to that section 106. Keep that in mind and reason to keep coming back. So, annotation here, judicial notice as to the location of street address within particular political subdivision. Propriety of taking judicial notice of geographic facts for purposes of proof in venue in federal criminal prosecution, and judicial notice of matters relating to public thoroughfares and parks. So there's some good references here. All right. Judicial notice as location of street address within particular political subdivision. All right. Now we're on to distances between locations. Boy. And just jump over here to the chat real quick and give it a quick refresh. And indeed, let's continue. Courts often take judicial cognizance. So judicial knowledge of the distances between two or more locations and the customary routes and usual time required for travel between them. So judicial cognizance means that they've put the judicial notice is in the form that the court can take knowledge of and apply to its decision making. The court is within its discretion in taking judicial notice of the distance between 2 points, for example, the distance between 2 cities, as is fact which the court can accurately determine from unquestionable sources. Let me read that again. The court is within its discretion in taking judicial notice of the distance between 2 points, for example, the distance between 2 cities. It's within its discretion, as this is a fact which the court can accurately determine from unquestionable sources. It's within its discretion because the court can accurately determine. Okay, so the court could say, check on their own references and say, yes, that's the correct distance between the 2 cities, or it's not. So they have that discretion because the court itself can accurately determine from unquestionable sources whether that's a fact or not. Although a court is free to take notice of the distance of an alternative maritime route, it is inappropriate for a federal court to notice judicially that parties would never contract for shipment over that geological distance, as the federal rules of evidence forbid the taking of judicial notice of facts subject to reasonable dispute, or of facts not capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. Whereas those sources there saying it would never do that, seems like it could reasonably be questioned. Never contract for that. Yeah. Never say never. And as we go through here, we see here an annotation, judicial notice of matters relating to public thoroughfares and parks again. So the same annotations we've been seeing here, and we're on to section 79, topological surveys. And let's check over here to the chat once again and see if we're refreshed. Hope everyone's still sticking in there. And indeed, looks like we're still refreshed here. And if you just come in, please hit the like. Make sure we get the notification out there. If any of you had your fill of feasting tonight, sit back and enjoy some of American jurisprudence for a nice nightcap here. Courts will take judicial notice of the system of surveys in a state, including the United States government survey. So the USGS can be judicially noticed. For example, a court may take judicial notice of a map bearing the seal of a professional surveyor in a defendant's prosecution for selling drugs within 1,000 feet of school property where the map is used at trial only to aid an officer testifying to the jury as the actual site where he made his measurements. Oh, gosh. Well, you get to see an example of judicial notice being used, even if it seems like it's a ridiculous case, as Graves versus State in Florida. On to Section 80, territorial extent of jurisdiction. All courts are bound to take judicial notice of the territorial extent of the jurisdiction exercised by the government, the laws of which they administer, and of the extent and boundaries of the territory under which they themselves can exercise jurisdiction. So the boundaries can be judicially noticed. Territorial extent of jurisdiction exercised by government. Section 81, public thoroughfares and parks. Now, this is an interesting one here, so pay attention to this one. Highway nomenclature and designations within the trial court's jurisdiction are matters of common knowledge and proper subjects for judicial notice. In matters involving geographic knowledge, it is not necessary that a formal request for judicial notice be made by a party, and therefore it does not require that the court formally announce that it is taking judicial notice of the fact. Therefore, courts will take judicial notice of the existence and general aspects of the street and highway system. For example, judicial notice may be taken that roads which are open to the public as of right constitute highways within the meaning of a state statute. Wow. For example, judicial notice may be taken that roads which are open to the public as of right constitute highways within the meaning of a state statute. C. 48. Stewart versus Davis in Mississippi. Interesting. Of course, footnote 47 came from the AmJur on automobiles and highway traffic, which we could review at a later date if there is popular demand. A court may take notice of facts relating to a road's physical and geographical characteristics, although potholes, and the area through which a road passes. There is, however, authority for the proposition that courts may not take judicial notice of whether the streets are within the boundaries of cities, or within the boundaries of a business or residential district. Can't take judicial notice of that, huh? A court may also take judicial notice of traffic conditions, the frequency with which a road is used, a road's importance to the community, the types of vehicles which frequent a given road, and the visibility of lights along a roadway to drivers. In addition, courts may take judicial notice of the existence, location, and purpose of stop signs, traffic lights, and various types of road signs which communicate traffic regulations to the drivers. Courts have also judicially noticed the function and purpose of toll stations, highway robbery, and the existence of sidewalk defects. Judicial notice may be taken of the characteristic functions and purposes of parks. You know, the purposes of parks are, right? We went through that through the AmJur too, is to ensure the happiness and mental health of the civilians living there, the inhabitants. So judicial notice may be taken of the characteristic functions and purposes of parks, or the major activities to which they are devoted. Beautiful wording here, and that's footnote 64. Newcastle versus Lawrence County in Pennsylvania, huh? Let's see here, yeah, interesting. All right. Judicial notice has also been taken respecting the authority under which particular parks and roads were constructed or regulated. Respecting the authority under which they were constructed or regulated. Section 81, here's our public thoroughfares supplement. Remember, this is from 1998, so this is the 1998 supplement. Although the court may take judicial notice of location of cities within county, it may not do so as to location of streets within our city. Wow, that's in Fulton County, Georgia, huh? Huh. Location of cities. It may not do so as to locations of streets within the city. Wonder why. Noting that blacktop construction tends to feather off and crumple at the edges under heavy traffic and severe weather conditions. Judicial notice that a highway was paved. Taking judicial notice that a particular parkway ran parallel to another street and of the distance between them. Court took judicial notice of fact that any increase in size of highway was bound to have some deleterious effect on environment. It is a matter of common knowledge that conversion of a 2-lane highway in a residential district into a 4-lane highway will be a detriment to adjacent property and may lower its market value, as we saw judicially noticed with the real estate section too. So this is where you see the two of them support judicially noticing something like this. Highway projects near a residential district. Writ of error over, what is this? Taking judicial notice of the importance of a particular state road in the system of state roads. That's in Florida. Wonder which road that was. Judicial notice that intermittent signs are placed along roadside of Garden State Parkway to inform motorists of individual regulations. Judicial notice that no U-turn signs were posted along divided portions of an interstate highway prohibiting vehicles from reversing directions by crossing grass divider or from one roadway to another. Yikes. They really wanted to give those tickets, didn't they? All right, we're on to section 82, waters and water courses. Let's jump over here to the chat and see where we're at. Yeah, Less TV, silent judicial notice or notice. I'd like to hear about that one. Bill Thomas says Nevada has a law forbidding the use of camels on highways in the state. I wonder why. It might have to do with what they leave behind. Nevertheless, I digress. Let's continue. So, waterways and watercourses. Courts take judicial notice of the location, source, size, and course of major rivers and other bodies of water within the nation or jurisdiction, and of their navigability. The courts will also judicially notice at what distance from the mouth of a river the tide ebbs and flows, although judicial notice will not be taken of the size of tidal lands or mud flats. Judicial notice may also be taken of the fact that a certain stream is or is not a navigable stream. Furthermore, while judicial notice may be taken of the navigability of more important rivers and streams, less significant waterways must be established in the same manner as any other question of fact. In addition, judicial notice will not be taken of the particular point between the mouth and source of a river where navigability ceases, since that is a matter requiring proof. Nice. As you can see, the waterways and the maritime things get very distinct here. Judicial notice is not typically something that's used in these situations here, as it likes to be codified. And with that, it takes us on to the next section for the next episode, which will be transportation, starting with the motor vehicles and their operation. So this should be a very interesting one. Looking forward to that one, and I hope you all are too. And let's jump over here to the chat and see where we're at. See, the Army brought them in as pack animals. They proved to cause trouble with autos. I think they leave behind a lot of turds, maybe. But then again, I think they don't. I think they hold on to it for a while. I think you touched on it. The court doesn't have to make a verbal notice. So, okay, Less TV. I think you're talking about when there's one where they're, let's see what that word was. Thanks for bringing that up. Let's just take a quick look here because They used a good word. And going over it again here now for everyone else would be good. I'll go back and look it up if I didn't, but it'd be better to share and have everyone do it together. Let's see, it was kind of near the beginning of it here. Let's see. It was something where they were supposed to be compelled to do it. They could do it. It's a really good word. Let's see here. And let's see. She's not in the state. Separation. Hate to digress like this, but I think it's important to, if anyone can remember the wording there, it'd be great. You can also look back and just tell me on the stream, or if not, we'll find it in a second here. It was before this part here because we were pretty early in it when we came across that term. Let's see here. This was being simplified when it's in a statute, but that wasn't it. Other particular matters, maybe it was under history. I think it was under the territory, the geographic parts. Yeah. It was under a geographic part. It had something to do with a distance between cities, particular location. Capable of accurate, right? Let's see. Oh, here we go. Here we go. Mandatorily, judicially noticed. There's our term for the day. Maybe I should pipe that into the chat, huh? What's that? Was it mandatorily, judicially noticed? Jeez. And there we go. Yeah, the courts have stretched the definition of navigable waters quite far. I'll say that. All right, Leslie, I hope you still stuck around for that. We found the word here. Yeah, I found it there. It's right here. Go ahead and pin it up there. So you all see that one. Mandatorily, judicially notice. So this is one situation that I think Les was mentioning here. There you go. Doesn't have to necessarily say anything about it. Doesn't have to make any kind of verbal notice or otherwise. It's you have to make a request either. It's mandatorily, judicially notice. So great term. Inlets and waterways, yeah, we went through that where they can't judicially notice certain aspects of those. And I could see why, because a lot of that stuff, it needs to be proved, and that can't be noticed if it needs to be proved. So, well, with that said, let's jump over here. Want to see something blatantly in your face? Image search Miami Fed Courthouse. Yeah, it's a pretty funny stuff with that one too. Yeah, that's I guess homework assignment there. Check that one out, everyone. Well, with that being said, I appreciate everyone being here. Let me unpin this thing here. Indeed, yeah, it looks like that way. There's a few other architectural anomalies there too that would pick some interest in people. In California, the bees have been found to fall under fish and game regulations. Huh. Wow. For the state. Interesting. Bees. Well, it's I guess it's a part of a economic aspect of it, and they probably claim it through those. And again, the economic these kinds of conditions and such can be judicially noticed and could have been part of the case for all we know. And it might be worth looking into. Also, if you wanted to say that perhaps they shouldn't be doing certain things like that, you could also have aspects being judicially noticed why they shouldn't be looking at bees as that, because maybe historically bees have not been looked at as any kind of protected animal. Yeah, admiralty law. Uh, I was going to go over some stuff with admiralty law, but looking it over, it's not entertaining to be the least, and rarely applicable unless you've got some kind of vessel. And in that respect, you'll find, I guess, vestiges of admiralty law sprinkled throughout all of the other laws and such, because it was had a broader history before the land-based laws, and most land-based laws are just around property. So it's a yeah, it's been applied. There's been analogies applied from admiralty into the other forms of common law, but they're just analogies in a lot of cases and not directly applicable. Which, in the case what we were just learning here with historical facts, just because they're ancient, they need to be verified or be able to resort to sources that cannot reasonably be questioned, not reasonably be questioned. And the fact that there could be some kind of dispute means that those aspects aren't necessarily eligible for a judicial notice. However, it is good to have these aspects in mind to see the layers of where the law comes from and how it's been practiced through time. So, with that, I'd like to thank you all for coming in tonight. This has been a very interesting one. I think I learned a lot from this. I hope you all did too. It's been a lot coming from the law of evidence, especially the judicial notice aspects of it. And I think that we continue on this, we'll continue to see more and more learning that would help benefit everyone, I believe, as we keep the dream of common law alive here on America. So, once again, happy Thanksgiving to all, and really want to show a shout out and a gratitude and a salute to the American tradition of common law, and the American jurisprudence has kept this country strong. So, with that said, salute to you all. Peace out. I'll see you all on the next one.